Mediation is really perfect when there's a long-term relationship, when you have what we often call family business disputes or even business divorce, to try to avoid that divorce. It helps parties to maintain a relationship. It maintains confidentiality also, as I mentioned before, and allows for a creative outcome. That's what's called enlarging the pie, or the win-win, because it's not just based on a legal determination. Parties can decide to, instead of paying a certain amount, come up with a new contract. Anything is possible in a mediation. So it's an opportunity for an amicable commercial resolution. So in domestic mediation, if you ask why choose, well, it's not always a choice. In many, many countries, if you go to court, you will be sent to mediation, or the procedural rules will force parties to negotiate or mediate before they even file a statement of claim.
Given then that impartiality and independence of the arbitrator is a key characteristic that underpins the legitimacy of arbitration as an acceptable dispute resolution mechanism, what do these terms actually mean? The meaning of independence and impartiality are closely linked. However, there is a distinction. Baroness Hale of Richmond in Gillies versus Secretary of State for Works and Pensions Scotland put it succinctly. Impartiality is not the same as independence, although the two are closely linked. Impartiality is the tribunal's approach to deciding the case before it. Independence is the structural or institutional framework which secures this impartiality, not only in the minds of the tribunal members, but also the perception of the public.
Just stepping back about what party autonomy is, arbitration goes back a long way, as you probably know by now. Many things about arbitration have evolved, but one thing that hasn't evolved is the cornerstone of the concept of party autonomy, and that means freedom of the parties. You find it enshrined in various forms of subjects that the parties can agree to arbitrate. And importantly, and this is a document I'll refer to, you find it in the UNCITRAL Model Law on International Commercial Arbitration. This UNCITRAL Model Law, as I'll refer to in short, is a model statute adopted either in whole or in part by many states around the world. And the aim of the statute is to harmonize the framework of international arbitration as countries tend to adopt it and use it as part of their legislation.